Welcome, I am the Loud Little Ducky. Today we are going over Owen's pretrial statements. We have a few more videos coming out. I'm going to try to get all of Owen's out by Monday, but the Greg Gillespie series is going to have to continue post-trial. But I want to get all this Owen stuff out prior to Monday. So let's jump into pretrial statements from Owens. So, David S. Gingras, Maricopa County, Superior Court, State of Arizona. Owens v. Eckerd, petitioner's pretrial statements assigned to the Honorable Judge Matta. Pursuant to Rule 76.1 Arizona Rules of Family Laws and Procedure, Petitioner Laura Owens, or petitioner hereby submit the following pretrial statements. Number 1, a brief description of the nature of the action. This case began as a paternity establishment action. Laura claimed she had sexual intercourse with respondent Clayton Eckerd, Clayton, or respondent, on May 20th, 2023. Prior to the filings, this action, Laura claimed she tested positive for pregnancy on 5 separate occasions. Yeah, she had 5 pee sticks. You don't need to put that in bold. We're all very aware of all the pee sticks in this case. May 31st, June 1st, June 19th, June 25th, and August 1st. After efforts to resolve the matter failed, Laura filed this case on August 1st, 2023. At that time, Laura was not represented by counsel and neither was Clayton. On October 16th, 2023, Laura had a lab blood test which showed an HCG level of 102. Although this test confirmed she was still pregnant. What? No, that test did not prove she was still pregnant. You can have HCG in your blood and in your pee when you're not pregnant. The HCG level on October 16, 2023 was far lower than would have been expected for a viable pregnancy. I don't think that you would still be confirmed as pregnant if you miscarried in July. From July to October, you're not going to be showing signs that you were still pregnant. Sorry, it's not happening. This indicated Laura was still pregnant on that date, but the pregnancy was virtually certain to end without healthy child/children being born. Okay. Whatever you say. Because, no. It doesn't make sense with the other things in the timeline, Gingras. Unsure of how to proceed, 2 days later, on October 18th, 2023, Laura filed a form requesting medication, a request Clayton did not oppose or even respond to. Laura will explain the intent of that filing was to give her an opportunity to inform Clayton that it appeared the pregnancy was non-viable and that Laura wanted to discuss this petition once the pregnancy loss was confirmed. Despite no objection from Clayton, the court denied Laura's medication request as premature a month later on November 19th, 2023. Unsure of how to proceed, 2 days later, October 18th, she filed a form requesting medication. Despite no objection from Clayton, the court. Why is she filing? She filed something in the courts to request medication so that Clayton would respond? And the court denied it even though Clayton did? What? Does anybody have that filing? The medication filing? Probably not. That might be a HIPAA violation, but what the hell is he talking about? Why are you filing something in court for medication? Okay, that doesn't make any sense. Somebody's going to have to explain that part to me. In the interim, on November 14th, 2023, Laura was seen by an OB/GYN facility called MomDoc, where it was confirmed she was no longer pregnant. After learning she was no longer pregnant, Laura filed no further pleadings in this matter and took no action to keep the case active. Because she is not an attorney and was not represented by counsel, well, that's because everybody doesn't want to represent her. Laura was not familiar with the process for seeking voluntary dismissal. I doubt that, because she has gone to court so many times. She's gone to court for 4 different men on many different issues. She has filed for numerous restraining orders. She has also had a contractor she's taken to court, as well as an Uber driver court thing. So I don't buy that she doesn't know how to do anything with court. That's just another lie, in my opinion. She didn't know the process for seeking voluntary dismissal. She assumed if no further actions were taken, the case would simply be dismissed for inactivity as confirmed by the administrative dismissal notice dated 12/4/2023. No, she didn't. No, she didn't. She didn't just leave it there. She could have figured out a way to tell Clayton this. She wouldn't. No, she was going to just let this sit. Clayton's counsel first appeared in the case on December 12, 2023, and immediately began filing various motions and pleadings without making any effort to meet and confer with Laura as required by Rule 9C. This caused Laura to retain her own counsel, who immediately appeared in the case and moved to voluntarily dismiss the action with prejudice on December 28, 2028. That's supposed to be 2023, not 2028. Laura was no longer pregnant. She asserted her petition was moot. This remains Laura's position today. Well, that wasn't the court's position because they decided to keep it open. Aside from the moot establishment petition, Clayton presents at least 2 or 3 arguable live issues for resolution. First, Clayton claims he is entitled to the judgment of non-paternity, which Laura interprets to mean a judgment affirmatively finding Clayton was not the biological father of any children Laura may have miscarried, as opposed to a judgment declaring the establishment petition moot and or that the circumstances rendered in any paternity issues inconclusive and thus impossible to determine. Yeah, he doesn't want that, because then Laura can still spread her lies. He wants her called out and told she can't do this shit anymore. That's what he wants. You don't want her to be able to just dismiss the case and then continue spouting off lies about him and continuing to ruin his reputation like she has done to everybody else in this series of men she's victimized. Nothing in Title 25, Chapter 6 permits the relief Clayton seeks. Rather, when an establishment petition is filed, the court may either find paternity is established, usually by applying one or more of the presumptions set forth in ARS 25-814A, or court may find paternity is not established because there is no evidence to support any presumption under ARS 25-814A, or because the presumption was rebutted by clear and convincing evidence per ARS 25-814A. Again, because Laura is no longer pregnant, her position in the establishment petition is moot, and there are no paternity establishment determinations for this court to make. That's what you think. Nevertheless, as the party asking for judgment of non-paternity in otherwise moot case, assuming the court does not merely dismiss the relief as legally unavailable, Laura's position is that Clayton bears the burden of providing by admissible evidence he is biologically excluded as the father of any children Laura was or may have been pregnant with. See ARS 25-807D, the party opposing the establishment of the alleged father's paternity shall establish by clear and convincing evidence that the alleged father is not the father of the child. To date, Clayton has produced no evidence disproving paternity beyond his own conflicting statements about whether he believes pregnancy was even possible here. I think multiple tests saying little to no fetal DNA, I think that's a pretty good thing to show he's not the father, or there's no baby to be the father of. y'all just want to think that that's just not possible. I cannot wait to see what she decides. In that, I actually don't think that Judge Mata is actually going to, I don't know if she's going to issue something from the bench on Monday, June 10th, but I'm wondering if she's going to take it under advisement and then issue her ruling at a later date, and then put everything in there. But man, would it be nice to hear her say stuff flat out. But I don't know that we'll get that. Second, Clayton asked the court to find Laura was never pregnant. Again, nothing in Title 25, Chapter 6 permits the court to grant such relief. However, if it did, as a proponent of the claim, Clayton must offer admissible evidence to prove his allegation. Again, to date, Clayton has offered nothing but pure speculation and conjecture to support this theory. Laura contends what Clayton is actually seeking is tantamount to a civil defamation claim over which this court lacks subject matter jurisdiction. Okay. Yeah, because there's not a defamation claim here. Not to say that that's not coming later. For that reason, Laura's position is this court cannot grant this specific relief as a matter of law, even if Clayton had compelling facts and evidence to support it, which he does not. Nobody is talking about defamation. We are talking about things that we have in evidence that prove that she is a liar and she cannot be believed. Third, in his amended response to Laura's petition filed January 26, 2024, Clayton requested sanctions under Rule 26 and fees under ARS 25-324. As explained in other briefing, Clayton cannot receive sanctions under Rule 26 because he failed to follow the strict requirements of that rule, and there is no pending Rule 26 motion. Furthermore, Clayton cannot recover fees under ARS 25-324 because Laura has not engaged in any unreasonable litigation conduct in this case. You are not the finder in fact on that. The judge will decide what is unreasonable in this litigation, and she has made a lot of unreasonable things happen in this case. She has committed criminal acts in this case. To me, that's unreasonable conduct. Why are you bringing up Rule 26 again? The judge already said, shut your mouth on that topic. She don't want to hear it. It's been closed. Stop talking about it. She's not going to make any further comments on Rule 26 sanctions. She's told you twice. To the extent Clayton incurred any fees after December 12, 2023, those fees were not caused by any unreasonable litigation conduct on Laura's part. Her discovery issues are a huge problem in this case. So, sorry, no. She caused a lot of problems with discovery, and that was after December 12th, 2023. That was well into 2024. On the contrary, if Clayton's counsel had simply met and conferred with Laura as required by Rule 9C, counsel would have learned Laura was no longer pregnant and there were no remaining paternity issues to litigate. Yes, there is, because she's a liar. He doesn't believe she was pregnant. Therefore, he's going to litigate that fact. And the judge told Clayton and them that they did not have to meet and confer with Laura because of how she's acted. And they have said they would. But it was going to be in public. There were going to be third parties there. And there was possibly going to be recordings. Because she cannot be trusted. And Woodnick nor Clayton were going by themselves or even both of them together without other people seeing it. Because she is a liar. An admitted liar at that. Clayton's decision to continue spending months litigating moot paternity issues in what amounts to civil defamation case filed in a court that lacks subject matter jurisdiction over that claim is unreasonable litigation conduct on his part, not Laura's, Accordingly, Laura is entitled to an award of fees and costs pursuant to ARS 25324. Finally, there is one separate issue remaining: Clayton's request for relief from the order of protection based on fraud. That issue has been fully briefed, and Laura's position has already been explained. There was no fraud in this case, and there is no basis to grant relief from the OOP. I don't agree with that, because she did get it, because she lied about that sonogram picture that you don't seem to want to address, Gingras. Let's see. Laura offered to stipulate to certain facts. Clayton refused to stipulate to any facts. Yeah, he's not agreeing with a single word that she says. 2. The parties' names is Owen and Eckerd. There is no minor child. No party stipulation agreement. Uncontested facts of the law. That's because neither one of them wanted to talk to each other, or Clayton didn't want to talk to her. Let's see what else. Detailed and concise statements of contested issues of fact and law. Pursuant to Rule 82A1, Laura has separately requested findings of facts and conclusion of law that has been provided detailed proposed findings on both issues. Rather than repeating those points here, Laura offers the following summarized list of contested facts and questions of law for the court to resolve. So basically you're just going to go over them, but you're not going to go into detail on them. Okay. We have already read the findings of facts and conclusions of law. We read through that earlier this week. So contested facts. A. Was Laura pregnant at the time she filed this case on August 1st, 2023? Ducky's answer is no. Did Laura have a good faith basis to believe on August 1st, 2023 that she was pregnant even if she was not? Ducky says no. Did Laura have any good faith basis to believe on August 1st, 2023 that Clayton was the father? Ducky says no. Did Laura continue to litigate this action after August 1st, 2023, knowing that she was not in fact pregnant? Ducky says yes. This little ducky says she knew, and she continued to litigate this case. What caused Laura to test positive for pregnancy 5 times before this action was filed if it was not caused by her being pregnant? That one is not going to get answered. We don't know. That's not been investigated. There are multiple ways for that to happen. It could be her epilepsy drugs. It could be, God, I hope she's not using her horse's HCG. There's multiple reasons. So that question, E, is not getting answered. What caused Laura to have HCG in her blood on October 16, 2023, if it was not caused by her being pregnant? Again, that one's not going to be answered. G, was the motion for voluntary dismissal filed by Laura on December 28, 2023, brought with a reasonable amount of time after Laura tested negative for pregnancy, thus precluding sanctions per ARS 12349C? H, has Clayton presented clear and convincing evidence to show he was not the biological father of unborn child Laura was pregnant with? I think that he has proved that she's not credible and that she is a liar and that we can't trust anything she says. Nobody can verify this pregnancy except for Laura, and she's not believed. So yeah, I think so. Little to no fetal DNA. I think that's some evidence. Contested issues of law. A, assuming, arguendo, that Laura violated Rule 26 by bringing or continuing to pursue this action without any factual basis, was she nevertheless entitled to the benefit of the safe harbor provisions of Rule 26C2B, even though notice of her right to withdraw or approximate court correct the alleged violations was never given. Oh my God. Oh, he goes on. B is about Rule 26 as well. Does Clayton admitted failure to comply with the safe harbor requirement of Rule 26 preclude an award of fees and sanctions under the authority, such as sua sponte award under Rule 26 or the court's own authority? Gingras. Rule 26 sanctions are not on the table. Those are moot points because Clayton's side withdrew their Rule 26 motion. The judge has told you twice nothing is happening with Rule 26, so shut up about it. Don't mention it. Why are you harping so much on Rule 26 when Rule 26 is not in effect anymore? And the judge has told you it's not in effect anymore. God, why do you argue? No, I know why you have to argue these same dumb points. It's because you have nothing else to argue. C. Does the fact Laura filed a motion for voluntary dismissal with prejudice on December 28, 2023, preclude any award of fees, costs, sanctions incurred by Clayton after that date? I believe it does. D. Does the fact that Clayton failed to meet and confer with Laura as required by Rule 9c prior to seeking leave to amend his response to Laura's established petition prelude any award of fees and costs sanctions to Clayton to extent those fees and cost sanctions were incurred after December 12th, 2023. So because Clayton didn't go talk to her, should he get fees and stuff like that? I don't think she's a person you can talk to. I think that's been well established that he shouldn't have talked to her. Like, you can talk to my attorney. And the things that she's accused, both of these, like, his attorney and him, like, Woodnick and Clayton have been accused by horrible things from Owens. Who wants to sit down and talk to her? I don't think a court should make somebody that does that type of stuff. I don't think a court should be able to force you to have to sit down with somebody that's accused you of horrendous things like that. That she can't be trusted. E. Does this court have subject matter jurisdiction to adjudicate civil causes of actions such as defamation and abuse of process, or must those claims be litigated separately to preserve each party's right to a jury trial? Nobody's... I think that in any case, if you were abusing the process and you're pulling a bunch of shenanigans, I think that can be brought up in any jurisdiction case. I think it is a case to case. If you pull it in this case, I can talk about it in this case. If you don't pull it in this case, then I can't talk about it. But if you pull it in another case, that can be talked about then. I don't think it has to be necessarily filed in court if the judge notices all the shenanigans. Defamation, yes, that will have to be proved elsewhere. And he can maybe Clayton can probably file for that later. But he has to get this first before he can even continue to go somewhere else. F. Is Laura entitled as a matter of due process to fair notice of the basis upon which sanctions are sought before sanctions may be awarded? Is Laura entitled to an award of fees pursuant to ARS 25-324 or other similar authority based on Clayton's unreasonable litigation conduct? Clayton is not the one who has been unreasonable in his conduct. Woodnick has not been unreasonable in his conduct. You and your client are the unreasonable litigation conduct people. 7. Position on each contested issue. Laura's position on each contested issue has previously been explained and other pleadings, so those positions will only be briefly summarized here. First, Laura and Clayton engaged in sexual activity on May 20th, 2023, which was by Clayton's own written admission sufficient to cause pregnancy. See Petitioner's Trial Exhibit A2, regardless of whether sexual intercourse occurred. Based on this admission, it is not necessary for the court to determine whether sexual intercourse did or did not occur. That point is ultimately irrelevant and immaterial to the outcome. I think it matters who the judge believes. And sexual activity and sexual intercourse are different. And unless Laura is this medical miracle marvel and pregnancy, that she can get pregnancy with semen hitting air, she can get pregnant with twins 4 times in a row, she can pee positive for HCG without being pregnant, she has vanishing twins syndrome, what else is she a medical marvel of? She didn't actually have miscarriages and stuff. She's just such a medical marvel. People really should study her, mentally and otherwise, because she's not this 1% in every medical category that ever existed. Second, Laura had a good faith basis to file this action on August 1st, 2023, because she believed she was pregnant and she believed Clayton was the father. Among other reasons, Laura's beliefs were based on the following points. Sexual contact between the parties on May 20th, 2023. Notice he does not put intercourse here. Laura had no other sexual partners near the time of conception, says her. 6 positive pregnancy tests, including a home pregnancy test taken by Laura on May 31st, 2023, which she took a photo and sent to Clayton. A lab test performed at Banner Urgent Health on June 1st, 2023. A home pregnancy test purchased by Clayton and taken in front of him. No, it was taken at his residence on June 19th, 2023. A home pregnancy test taken by Laura on July 25th, 2023. A home pregnancy taken by Laura on August 1st, 2023. And a blood-based lab test taken by Laura on October 16th, 2023. Clayton has alleged all of the above tests, including the one he purchased, are either fake or somehow unreliable, but he has zero admissible evidence beyond pure speculation to support that claim. Well, if he believes that there was never a baby, and she can't prove there ever was, other than a pee stick, he can deem those unreliable. There's something fishy going on. Laura's normal monthly period stopped after May 2023 and did not resume until November 2023. Laura passed tissue on July 23rd, 2023, which may have been a partial or even a complete miscarriage, although she continued to test positive for pregnancy for months after that date. Laura gained weight between May 20th, 2023 and November 20th, 2023, and then lost approximately 40 pounds after November 2023. Laura experienced significant swelling in her abdomen area as documented by photos and videos Laura took at the time. Why are you saying swollen abdomen instead of a pregnant belly? Why can't you say pregnant belly? We do not describe pregnant bellies as a swelling abdomen. That is so bizarre to me. Like, red flags with that statement. It's so weird. Laura felt pregnant between May and November 2023, experienced extreme morning sickness, fatigue, frequent urination, tender breasts. That is the first time we are hearing any pregnancy symptoms mentioned. These symptoms have never been mentioned until now. Because I was just talking about how we have never heard her talk about all the things that a lot of women deal with. Not every woman, but that. Frequent urination, BS. She went for 2 hours, 2.5 hours, whatever it was, without needing to pee. If she's suffering with frequent urination and she was that far along with 2 babies in her, she would not have been able to last that long. Sorry, not buying it. I've been a pregnant ducky before. No. Third, an expert OBGYN with decades of experience, Dr. Michael Medchill, has reviewed Laura's medical records and based on that review has concluded she was in fact pregnant with the level of certainty of 99% plus. Clayton's experts do not dispute or even respond to any part of Dr. Medchill's opinions. You've been proven wrong on this before, Gingras. Yes, they do. They talk about it. I mean, this is like, this to me, the cross of this expert opinion, when Dr. Medchill comes up, is going to remind me a lot of the Daybell expert on, like, autopsies, if y'all watched any of the Daybell case. And they were like, oh, I don't see how they could have determined it was a homicide. They should have put it as undetermined. And then the prosecution got up there and said, did you review this in your expert analysis? Did you review this in your expert analysis? Did you view this to come to your conclusion? And he's going to be like, no, I didn't know about that. No, I haven't seen that before. No, I haven't heard that before. So you didn't have all the facts to make a conclusion. And then, of course, Gingras is going to be like, well, if you would have had any of those things, would that have changed your opinion as of now? And it'd be, no. Okay, well, you didn't review everything. So how would you even know? And again, it's not Medchill's fault. But Gingras is going to make Medchill look like a chump, unfortunately. Because he doesn't have all the relevant information. Fourth, aware that Clayton has claimed Laura's pregnancy was fake, Dr. Medchill has reviewed Laura's medications as documented in her medical records and has concluded that none of those medications would produce false positive pregnancy tests. Again, Clayton's experts do not challenge or even address this conclusion. Seizure medications can cause positive HCG. We went over this in my positive HCG video after a hysterectomy. That could I believe that I was pregnant because I had a positive HCG test at the hospital? No. Fifth, Laura's conduct during this litigation is entirely consistent with a person who believed they were in fact pregnant. Among other things, in mid-August 2023, just 2 weeks after this action was filed, Laura paid $725 to a company called Rabgen for DNA testing to be performed on her and Clayton. No. A person that is actually pregnant would never forge their ultrasound. They wouldn't have to. A person that was pregnant would go seek prenatal care if they were in her shoes. A person who was pregnant or even believed they were pregnant, if they started bleeding a month to 2 months into their pregnancy, they would have gone to the hospital. So no, her entirely consistent with a person who believed they were in fact pregnant is bullshit. Because I don't know one woman who would have done that. Assuming Laura knew she was not pregnant in mid-August 2023, she would have known the Ravgen test was 100% guaranteed to prove she was not pregnant. No. She figured out that it can say little to no fetal DNA 20,000 times. That doesn't prove that she wasn't pregnant. Because remember, it's inconclusive or it's ongoing. Well, what else can little to no fetal DNA mean? It can mean that there's no DNA of a baby to get any DNA from to determine paternity. That's what that can mean. It's also notable that Clayton's initial promise to participate in the Ravgen test but failed to do until weeks later. Okay. You know what? It's going to be more accurate later. Before Laura miscarried. It is entirely possible the test results may have been different, even if Ravgen results were conclusively negative, which they were not, because they don't give out negatives. We have them on the phone saying that, or something from them stating that they are not going to rule it as a negative. You will never get a result from them that says negative. It will always say little to no fetal DNA. They will not give any 100%. They don't even do it if you're 100% the father. They will not give 100%. And they're not going to 100% guarantee that you're not the father either. So the closest they can come to that is little to no fetal DNA. This case should have ended much sooner without a single penny of fees incurred by either party. If your client would have fessed up, would have stopped doctoring evidence, it would have been over a lot sooner, I'm sure. But she didn't. In light of facts, no reasonable person would have agreed, indeed demanded, to perform the test with Ravgen if they believed they were not pregnant at the time. The only plausible explanation for Laura's insistence on the Ravgen test is that she was, in fact, pregnant, or that, at the very least, she believed she was pregnant. She brought up DNA testing with Gillespie as well. She brings up DNA testing all the time. She is pretty well versed in how to pull all this stuff off because she's done it multiple times. To the extent Clayton disputes any of the above points, his position is based on entire speculation, conjecture, and improper propensity of evidence offered by two of Laura's ex-boyfriends, both whom have restraining orders entered against them, and both whom are strongly motivated to lie. Rumor, speculation, and inadmissibility innuendo cannot support the extreme relief Clayton seeks in this case. No, but it can give him more satisfaction in his belief, knowing that she has done this to other people, that he's not crazy. She's got an order of protection against Clayton. Okay, so she's got an order of protection against him. She's got a restraining order against the other two. I don't care what her restraining orders and orders of protection are. You cannot truly believe that she is being honest about everything, Gingras. You just can't. Like, nobody is that dumb. Furthermore, even if the claims of Laura's ex-boyfriends were both credible and admissible, which they are not, any statement Laura may have made during a previous relationship have no bearing on the fact that she was pregnant in this case. There is more than sufficient independent medical evidence in this case to support a finding that Laura was pregnant, all other past credibility issues aside. The reality precludes the relief Clayton has spent the last 6 months demanding. 8. Spontaneous spousal maintenance, parenting time, list of petitioner's witnesses. Owens, Eckerd, Medchill, and potentially Jan, Owen's mother. Her sister's not getting up here to testify. Nobody else can verify that she was pregnant. Not a single person. And her mom's going to get up there and perjure herself. Because she's surely not just as blinded. She's not blindly following this. She's trying to protect her daughter, and it's just, she needs to stop enabling it. She needs to tell her daughter enough is enough. Cut this shit out. It's cost us a lot of money as a family. 11. Designation of deposition testimony pursuant to Rule 59 and without waiving any other objections to the admission of this or any other testimony by the same witness, Laura designates the following deposition testimony. The entire deposition of Michael Maraschini, dated June 13, 2018, bearing Bates stamp. Petitioner's Trial Exhibit A23. Excerpts from the deposition of Clayton Eckerd, dated February 2, 2024, attached hereto as Exhibit A. Witnesses. Objections to witnesses. Laura objects to the following witnesses who may be called by Clayton: Greg Gillespie, Mike Maraschini, Matt Mulvey. Haven't you already tried to exclude these witnesses in a motion in limine, and the judge denied it? I don't think the judge is going to like any of this because she's already denied your motion. But he's going to re-argue it again. As to these witnesses, Laura objects to on the following grounds: lack of timely disclosures. Clayton has never disclosed a fair substance of anticipated testimony of each witness as required by Rule 49, and the majority of the information he has disclosed was untimely because it was not disclosed within 30 days as required by Rule 49B2B. He told you about these people prior. So, no. Relevance. The testimony of each witness is irrelevant to any material fact in this case. As such, the testimony is inadmissible per Arizona Rule of Evidence 402. Inadmissible character propensity. The testimony of each witness is not admissible to extent to offer the show. Because an angry ex-boyfriend claimed Laura lied in the past, she must be lying now. Such propensity evidence is inadmissible. That is not what they are doing. They are not saying that because she lied in the past, she's lying now. It is to show a pattern that she's done this to people. Like, I think the judge has a right to know this stuff because it's one of those 1 in a million things. There's just no way. Improper specific instance evidence per Arizona Rules of Evidence 608B. As to Mr. Maraschini, Laura further objects to him testifying for additional reasons. First, Clayton never disclosed contact information for Mr. Maraschini as required by Rule 49I. Instead, the only contact information disclosed for Mr. Maraschini was the name of the attorney in California, Randy Pollack, who informed Laura's counsel in writing that Mr. Maraschini would not testify at trial. See Petitioner's Trial Exhibit A27. Because it appears Mr. Maraschini's counsel either lied about his intent to appear at trial or the person identified by Clayton's disclosure as Maraschini's attorney did not, in fact, represent him. Clayton has failed to comply with the requirements of Rule 49I as to Mr. Maraschini by failing to provide valid contact information for this witness. The one fact precludes Mr. Maraschini from testifying at all. Gingras, when she replied, when the judge talked to you about this, she pointed out that Mr. Maraschini directly reached out to you And she knows Maraschini directly reached out to you and you want to claim that you didn't know anything and you don't know why he's testifying. But you clearly know why he's testifying and what about. And he personally contacted you. So saying I wasn't able to talk to him is a lie. Second, Laura has a current valid DV restraining order against Maraschini entered by the San Francisco County Superior Court. This order requires him to have no contact with Laura, and he is required to keep 100 yards away from her at all times. The order contains no exceptions for in-person testimony in this proceeding, and this court is required by federal law to give a full faith and credit to the California court's order. So here he is, still threatening Maraschini, that if he shows up to testify against her, further victimizing Maraschini, that everybody's breaking California's court order. It's just like, wow. So, is he supposed to be there by Zoom? He has a subpoena to be there. So, what is he to do? Like, he's got a subpoena in this court to show up, and he's got a court order that he has to stay away from her. He's got court orders in both places now. I think the judge will write a letter explaining her decision if something like that happens. Because she knew that this was in place when she allowed him to be subpoenaed. Like, she would have turned it down. I just don't think that argument's going to fly. Accordingly, if Mr. Maraschini appears at trial without permission from the California court that issued the original order, he will be committing a crime and will be subject to arrest pursuant to ARS 133602R. This issue has been reported to court security by undersigned counsel, who has requested that Mr. Maraschini be arrested if he violates the DVRO as the law requires. So, still threatening the arrest of Maraschini. After saying, oh, it wasn't a threat. I withdraw my threat. You're still threatening to have him arrested. So we'll see. Will Maraschini be arrested on Monday? Because that's going to open up a whole nother can of worms. They've requested that he be arrested on Monday if he shows up, even with a subpoena from this court. So either way, he can get arrested for not showing up with the subpoena. He could be arrested in the Arizona courts for failing to show up for your subpoena, and then here he can be arrested for showing up because of the California thing. It's fucked up. Excuse my language, but it is. Laura further reserves the right to object to Clayton's expert Dr. Deans to the extent her knowledge, education, training, and experience do not meet the requirements of Arizona Rules of Evidence 702 for the specific testimony she intends to offer. She gave her expert report, but okay. Laura further objects to the testimony of Clayton's computer expert John Berryhill on the basis that this testimony is irrelevant and offered solely for the purposes prohibited by Arizona Rules of Evidence 404B. Clayton has failed to comply with the disclosure requirements of Rule 49J because Clayton did not timely disclose the substance, facts, and opinions of which the expert will testify. Clayton has also failed to disclose the original underlying computer files from which form the basis of Mr. Berryhill's opinions as required by Arizona Rules of Evidence 1002. To the extent Mr. Berryhill is being called solely as a fact witness, this disclosure is also untimely per Rule 49B2B. It was given to you. The report was given to you. You were notified about it. It was submitted prior to the discovery deadline. So it was not untimely. You chose not to hire a forensic expert to take that thing to. You were also not just going to be, you and your client were not going to just be given free access to his computer, because she can't be trusted. And I don't know that you can be either. 13, trial exhibits / objections. Laura designates the following trial exhibits: timeline of events, Banner Health pregnancy positive test, email, something to consider to test, borrow records, Planned Parenthood visit. She didn't go to Planned Parenthood. Dr. McCool's records, Ravgen correspondent, belly video number 1, belly video number 2, email medical confirmation, any lab tests now, the 102 HCG, belly video 3, mom doc records, Dr. Medchill's disclosure and report, purchase contract of Lynn Oak, purchase contract of North 76th Street. Those have no relevance in this case. The real estate is not this case. The ADRE ruling, records complaint, 1 medical records, order of protection, register of actions, in a case number, Laura's original declaration, Laura's renewal declaration, Mike response to petition, deposition of Mike Maricini, protective order, original, minutes for order renewal, protective order renewed, email from Randy Sue Pollock, Woodnick Law Press release, an injunction against harassment docs. Clayton has not yet designated or identified his final trial exhibits. Therefore, Laura reserves the right to raise specific objections when and if such trial exhibits are disclosed. He disclosed those. He put them in his pretrial statements. To the extent Laura is aware of certain specific exhibits Clayton may use at trial, she offers the following objections. Of course she does. 2,500 pages of text messages disclosed by Clayton on May 7, 2024. Laura objects on the basis of untimely disclosure per Rule 49, failure to disclose original source files per Rule 49, relevance, evidence Rule 402, hearsay, evidence Rules 802, lack of authenticity, evidence Rule 901, lack of original evidence Rules 1002, failure to make original available evidence R 1006. Evidence of emails and documents exchanged between Laura and Mike Maricini's untimely disclosure per Rule 49, failure to disclose original source files Rule 49, relevance Rule 402, hearsay 802, lack of authentication 901, lack of original 1002, failure to make original available 1006. Evidence of a dating contract, inadmissible, compromise offers and conduct or statement made during negotiations. Evidence Rule 408. No. No, no, no. You can bring the dating contract in. I don't see why this can't be brought in. I would overrule that objection. Evidence of audio recordings from Greg Gillespie, untimely disclosure per Rule 49, failure to disclose original source files, Rule 49, relevance 402, hearsay 802, lack of authenticity 901, lack of original 1002, failure to make original available 1006. Evidence of emails and documents exchanged between Laura and Greg Gillespie, untimely disclosure per Rule 49, failure to disclose original source files, Rule 49, relevance 402, hearsay 802, lack of authenticity 901, lack of original 1002, failure to make original available 1006. So those are her objections. I think she has all of this stuff because she was a part of it. It's not untimely disclosed because she is part of that. Probably is in the case files of previous litigations, and they have been ruled authentic or whatever. Like, no. 14. Statement re completion of discovery. Laura agrees that except for certain matters discussed above, all pretrial discovery and disclosures has been completed by trial date, and that the parties have exchanged all exhibits and reports of experts who have been listed as witnesses. 15. Statement re good faith settlement disclosure. Laura agrees the parties have engaged in a good faith settlement discussion. Those efforts were not successful. So they agree that they have tried to have a good faith settlement discussion. B. Laura requests and will seek by separate motion an award of fees and costs pursuant to ARS 25809G, 25324, and 12349. Trial record. Laura has requested the trial be transcribed by court reporter pursuant to Maricopa County Local Rule 2.22, dated June 3rd, 2024. So his was filed the same day that Woodnick's was. They both filed on the same day. So good for them. Copies were sent to the correct people, and David Gingras signed his stupid name. So Clayton answers, she got on top of me at one point. Corey Keith says, and can you explain what you mean with, I know this is sort of a difficult topic, but can you explain what? Clayton says, I don't care at all. So Corey goes back and says, you mean with body positions when you say she got on top? Clayton says, yeah, she got on top of me, and I was laying down like this, and she was straddled on top of me and making out. And I guess there was my P and her V were in close proximity, but there was absolutely no penetration at any single point. Nor would it have ever been possible for her to have gotten pregnant, because 4 hours in between, semen doesn't survive that long. Corey says, okay, and so how long were you guys kissing, her being on top of you? How long was that taking? Woodnick objects. Foundation. Clayton says 15 to 20 minutes. Mr. Keith says, okay. Then it transitioned, I believe you said, back to oral again? Clayton says, correct. And then you testified this time, I believe, a little bit differently. You testified that I believe, and it ends there. Go on to the next page. No. And what happened after that? Clayton says, we went to sleep for about 3 or 4 hours. Corey says, and did you guys put your clothes back on? Clayton says, no. Corey Keith goes on to ask, okay, and so what happened from there? Clayton, we re-engaged about 3 or 4 hours in from the last time, and she performed oral again, and at that point she performed oral. I finished. She went to the bathroom. I don't know what she ended up doing with the semen. Corey Keith says, let me slow you down a little bit. You guys are sleeping. You wake up at some point. How does it transition into getting physical with each other again? Clayton says, started kissing again, fondling, and then she started performing oral. Corey says, kissing, fondling, were you guys cuddling in the bed at this time? Woodnick objects. Foundation. Clayton says, yes, we were, I guess, cuddling in close proximity. Mr. Keith says, and was there any sort of like grinding on each other? Poor Corey Keith has to go through this and ask these horrible questions, and he has to play dumb because he has to have it broken down and it explained. He's really not that dumb. I hope he's not. I don't think he is, but poor guy has to ask about this awkward topic. It's just so weird. I feel so bad for him. That was other part of it. In front of you, presumably? So this is talking about the pregnancy test. Yes, although she would not pee in front of me, but yes. Corey says, understood. And did you purchase that pregnancy test? I did. And Clayton says, let's call it an HCG test because we know that she was never pregnant. Corey says, well, on the box, did it indicate that it was a pregnancy test? Clayton says, sure, I guess that's what they market it as for people that are actually truthful and take these tests and don't lie. Corey says, okay, so you purchased this pregnancy test. Did you tell my client prior to her arriving at your house that you were going to ask her to perform this pregnancy test? Clayton says, no. Corey Keith goes on to say, and then you showed her or asked her about the pregnancy test. What was her response? Clayton says that she had already taken one and she brought one with her so that I could see it and she'd be happy to take the test as well. And then it says something, I can't read part of that. Feel like I saw, he says, I didn't feel like I saw anything in her pockets. Not to say she didn't have something pushed up inside of her. I didn't check that. But she wasn't carrying anything into the bathrooms. Corey says, okay. And she did perform the pregnancy test. Did she show you the results? Witness objects, form, foundation. Clayton says, yeah, I saw the test. Corey Keith says, and what were the results of the test? Witness says, form, foundation, because he should specify what test and what results and stuff like that. But Clayton answers, there was one line and one faint one. Corey Keith, so there were two lines. One was more faint than the other. Clayton says, yes. And at this point, did you believe that she was pregnant? Clayton says, I had a moment of disbelief, but yeah, at that moment I thought maybe she had actually successfully trapped me by inseminating herself. That was my belief. So the line was faint, is what Clayton is saying in this. And most of the time on pregnancy tests, like how often is this, like on her pregnancy test, how often are these lines faint? Because a lot of people, some may be faint, but at one point, like as when you're far enough along, they're just in your face. Like it's not faint, it's in your face. Like no doubt you are pregnant. So that's something I would like to know about these other ones. How faint was the lines on all these other pregnancy tests that were further on into so-called pregnancy? That is what I wonder. Corey Keith goes on to ask, so when you say give her a chance, you are referring to, if I am understanding correctly, you would give her a chance with regards to the two of you having a relationship. Clayton says, yes. It was a lie. I had no intention of dating her, but I was going to just basically tell her what she wanted to hear to see if she would go away. Which is exactly what Greg did, which is exactly what Maraschini said. I don't know about Matt, but I'm sure similar. So Corey Key says, and what do you mean by that is to see if she moved forward with an abortion? Is that correct? Clayton said yes. Corey Keith says, and was this after my client came over to your house and conducted the pregnancy test? Clayton says yes. Corey Keith asks Clayton to read that text message out loud, please. Clayton reads the text message that says, this is the last time I will communicate with you on this matter. I would like for you to get an abortion if you are pregnant with my client, which I still don't believe, but it doesn't matter either way. If you do not, that is your choice. And in this case, if it ends up being my child, I've decided that either you will take 100% custody of the child or it will be put up for adoption. I will not be raising it in any capacity. Corey Keith says, okay, this is an accurate depiction of the text that you wrote to my client. Clayton says, yeah, I texted that. Question, okay. And isn't it true that you actually doubled down on that? You sent her an email with, and whatever that is. Okay, he said he wasn't going to be involved in raising the kid. That's it. Like, he has that choice. It's a douche choice if he actually did that, but it's his choice. So it starts with ejaculated into her mouth, and then what happened from there. Clayton says she went straight to the bathroom and I went to sleep. Corey Keith says, okay, you said there was no intercourse between you and Miss Owens, correct? Clayton says, correct. Corey Keith then asks, why wasn't there intercourse between you and Miss Owens? Clayton says, because she said she didn't want to, so I said okay. I respected that, and I didn't push it. So Clayton right there is saying he didn't ARP her. She didn't want to have intercourse. I mean, like, good for her not putting it out on that particular date, but she did everything else. Still doesn't make you a classy girl, Owens. So he's saying this. So when Gingras is putting this stuff out, it's like, what does that prove? That is exactly what Clayton's story has been. They didn't do it because she didn't want to, and he respected that. Now Owens is like, no, we did do it, and then later down the line she's like, no, he did it without my consent. So Clayton's story is he respected her choice not to do it. Corey Keith says, question, during your podcast interview, you stated that, quote, the grinding occurred as we were leading up to the climax the second time, end quote. Do you recall making that statement? Clayton says, yes. Corey Keith says, is that an accurate statement? Clayton says, yes. Corey then asks, how much time lapsed between the end of the grinding and you and your happy ending, basically? Answer, probably 5 minutes, because, you know, about 5 minutes. Corey then asks, okay, was this the only ever instance of physical or sexual contact between you and my client? And when I say that, I am not inferring that you guys had, and I'm thinking it's going to say sex, but those are the exhibits of the deposition of Clayton that Gingras wants to put so much effort on. And I don't think it proves anything except for that his story is still the same to this day. That is Owen's pretrial motion. She has since added an addendum, which we will also be making a video about. So look for that. Our quote of the day that we're ending with as a trial is 2 narratives competing for your attention. Well, these 2 narratives have got our attention, and we believe one of them and not the other. So that's basically what a trial is. Whose truth? Who's credible? What do we believe? Prove it to us. Thank you for watching this video. Please hit that like button, subscribe, share. We are almost at 500 subs and moving on to 1,000. And I will see you next time. Bye.